Western Cape High Court dismissed Public Protector Busisiwe Mkhwebane's interdict bid. A hearing on the validity of the parliamentary rule is penciled in for late November, if the Public Protector still wants to pursue it. To discuss the legal merits of this case, I'm joined by attorney Akani David Sithole. Akani, very good morning to you. Thank you for your time. The Public Protector is essentially hitting back, but before we even get there, is the Public Protector correct in arguing that Parliament's rules to remove the head of a Chapter 9 institution are indeed unconstitutional?
Greetings to the viewers at home. So the Parliament is authorized to issue rules to govern its own internal processes, that is, to give effect to the constitutional mandate to hold the Public Protector accountable. But the question that is raised by the Public Protector is the aspect of the Audi Alteram Patem rule, to say there is no sufficient provision within the rules to ensure that she is properly heard. There are no aspects in those rules that give authority or make room for persons who find themselves to be conflicted to be removed. So she has raised some of those issues, but the court found that at this stage she could not prove that there will be irreparable harm should Parliament not be interdicted.
Now, the High Court has, listed the severity of the charges that have been preferred against her, exactly just to getting an understanding on how severe these charges are and what they speak to in terms of the Public Protector's understanding of the Constitution.
Indeed, the motion which has been accepted, admitted by by a speaker are severe. And these are matters which will be determined as it goes forward, as the Speaker appoints the investigating panel to assess whether there is merit in those. So what was brought before the court was the aspect of halting those proceedings to enable Parliament to actually investigate. So the Public Protector sought that the court halt that process. But then the court found that at this stage, even if that investigation does proceed, if there are issues at the later stage, it's issues which the Public Protector can take and does not have to be prevented in conducting its accountability duties at this stage.
So with the High Court essentially giving the nod for the Public Protector's impeachment, what needs to be understood about the process of an impeachment and the seriousness that comes with it?
Once the National Assembly has adopted that motion which has been presented, firstly, it affords the President an opportunity, if he so wishes, to suspend the Public Protector pending the finalization of the investigation. But importantly, it affords the National Assembly to appoint an independent panel that comprises of experts to ensure that they assess if there are merits in those cases, and affords the Public Protector an opportunity to respond to those allegations that have been brought by way of documentary evidence, by way of recordings that will have been made available to the panel of experts. Then the Public Protector will respond to say, these are the allegations that are brought before me and this is my response to it. The panel will then prepare a recommendation to say whether such proceedings should indeed go forward or whether there is no merit. That will be sent back to the National Assembly for the next steps to follow.
At the same time, the Public Protector has essentially hit back following her defeat in the High Court yesterday. She says the judgment goes against the ruling by the Constitutional Court, which bears similarities. As we try and make some sort of understanding and sense of this judgment, what legal recourse does the Public Protector have? What are her next steps should she want to continue in her quest to fight this?
Well, an interdict is generally considered to be an interim order which is not appealable unless if its effects are found to be final. So under the circumstances, the best way for the Public Protector is to subject herself to an investigation. What is there that the Public Protector stands to lose when an inquiry is held? The duty of Parliament is to hold the Public Protector accountable. And she should equally present herself before Parliament to be held accountable. If there are issues with the rules as it goes on, if, for example, there are persons who are found to have conflict in the matter, conflicted in that the Public Protector has previously granted adverse findings against them and they find themselves with information that need to assess the public protector, the public protector can then raise those issues within those committees. And if it fails, then the public protector can then challenge those specific findings within those provisions and not to challenge the entire accountability exercise as a whole by preempting that there may be difficulties which may well not be there.
The public protector has essentially suffered many blows in court, and really a lot of strong wording coming out in terms of some of the judgments in her understanding her role, understanding the Constitution and the powers of her office. What does all of this, and including this very latest incident of yesterday in terms of the High Court, what does it speak to when we take a look at the integrity of her office?
Indeed, there have been findings, adverse findings against her, strong-worded judgments against her, and that speaks to one of the requirements for the removal of a public protector. You'll remember we've got 3 grounds you can remove a public protector: for incompetence, for incapacity, and for misconduct. So the aspect of her, or as per the judgments, relay, her not understanding her role, speak of the aspect of competence. So that is a prima facie ground that can be brought and, of course, investigated in full by the independent panel, debated in Parliament, and voted upon whether indeed she is incompetent. So if the National Assembly indeed finds that she is incompetent and they vote, the two-thirds majority vote in favor of her removal, then the President will have to remove her based on the aspect of incompetence justified by those judgments that have been delivered against her.
And very lastly, before we let you go, Akani, as you assess this matter in all its merit, as a legal expert, what are some of the concerns that come with this, as well as the leeway and the perhaps angles of opportunity?
Well, firstly, holding the public protector to account is something that must be done with caution, partly because the very role of the public protector is to investigate people in government. And the people in government find themselves in the National Assembly. So when they are these investigations, which are done without proper assessment, if they are done without proper assessment, then it may really have a chilling effect on the public protector in conducting investigations against certain persons. So there must really be that opportunity granted to the public protector to present the story properly and investigations be done properly to ensure that other public protectors or office bearers of that office ensure that they work without fear, favor, or prejudice.
Very well. Thank you so much for your time, Attorney Akani David Sithole, giving us a sense on the big story of yesterday, of course, the High Court judgment against Public Protector Busisiwe Mkhwebane.